Hello and welcome to our video series for Indigenous business during the coronavirus pandemic. I'm Terri Janke from Terri Janke & Company, lawyers and consultants. We are working with Indigenous Business Australia and 33 Creative to bring you information about how Indigenous businesses can respond to the coronavirus pandemic. In this video, we'll take a look at what to do when things get too tight and it can no longer be business as usual. You'll have to act quickly so that in the long run, you can return to business when the pandemic is over. Firstly, check your cash flow weekly. Remember to check your cash flow regularly and be realistic about your ability to pay your staff and other debts. Ask the question, do I have enough money to get through the next 3 months? If it is looking doubtful, you are going to have to act fast. A sole trader will have more movement to minimise their business when not having to deal with large payments to employees or contractors. However, if you run a company, you will be caught by the insolvent trading provisions of the Corporations Act. If you operate your business as a company and you're a director of the company, you have a legal duty under the law to not trade insolvently. A company is insolvent when it is not able to pay all of its debts as and when they fall due. You are allowed to take into account money that the company has and that is reasonably expected to get or to borrow. Ordinarily, under Australian corporations law, a person will be liable if they are a director at the time the company incurred a debt and there were reasonable grounds to suspect insolvency. The director will be directly responsible, which means they personally could have to pay for the debts of the company. There are also stiff penalties for trading insolvent. Civil penalties include fines of up to $200,000. Criminal penalties also apply if a director is found to be dishonest, and that is a factor in the insolvent trading. A director may face a fine of $200,000 or be imprisoned for up to 5 years, or both. If found guilty of a criminal offence, the director will be disqualified from being a director of a company. However, the government is relaxing insolvent trading laws during the coronavirus pandemic. On the 26th of March 2020, the government announced that it would temporarily relax the insolvent trading law to support businesses in difficult market conditions. Generally, where there were strict obligations, the federal government has decided to relax laws that relate to insolvent trading. The federal government has now removed the risk of a director being personally liable for any debt incurred by a company in the ordinary course of the company's business for a 6-month period. A new temporary change states that directors will not be personally liable at the point they suspect the company may be insolvent and they start taking action that will lead to a better outcome. It's obviously essential to obtain appropriate qualified advice from an accountant and develop plans. When you speak to your accountant, it is essential to give them all of the facts. Directors will continue to be subject to directors' duties, including acting in the best interests of the company and acting in good faith. Other relevant changes related to insolvency have also been put in place. The government also introduced changes to the bankruptcy law for 6 months from the 25th of March 2020. The temporary changes include raising the debt threshold for a creditor to apply for a bankruptcy notice against a debtor from $5,000 to $20,000 and extending the time frame for a debtor to respond to the notice from 21 days up into 6 months. There was also a temporary increase in the threshold at which creditors can issue a statutory demand from $2,000 to $20,000, and the time of response that a company has to respond is increased to 6 months. Wages to staff are a big component of a business's costs. If you have to put off employees, it is important to get legal advice to avoid possible wrongful dismissal action. While there are stand-down provisions in the Fair Work Act, these are strictly limited circumstances. An employer may be able to stand down an employee if the employee is unable to perform their duties due to the coronavirus. The employer can stand down the employee without pay in very limited circumstances. The disruption must be outside of the employer's control. For example, if the government has directed the shutdown and the business is not able to open. An employer will not be able to stand down an employee if the business is quiet or there isn't enough work, even if the coronavirus is ultimately the reason for that. It is essential to get advice before you stand down any employee. If an employer can lawfully stand down an employee, the employer doesn't have to pay the employee during the stand down period. If you do not apply for the stand down period, you must continue to pay the employee or dismiss them by making them redundant. Generally, there's no other choice, and that is why it's critical to look at the employment agreements, the awards and any enterprise agreements. To find out more, go to the Fair Work Commission's website, www.fwc.gov.au, and search Standing Down Employees. If stand down does not apply, the employer may be able to negotiate with the staff to use their holiday entitlements during the downturn. However, no employer can lawfully negotiate an agreement that is lower than the employee's entitlements under an award, an enterprise agreement, or lower than the national employment standards. If you cannot continue to pay staff wages, you may have to end the employment because there is no longer a position. Check the employment agreement, award, and enterprise agreement on processes for terminating agreements and redundancies, and make sure you follow the strict legal criteria. Employers should note that making people redundant during this time may mean that you have to pay redundancy pay. There are exceptions for small businesses that have less than 15 people. You should seek advice before making a decision involving redundancies. You may be able to seek financial assistance in the short term, but be careful to assess the risk and make sure that you are able to service the loan when business returns to normal. Even if the relaxed laws on insolvency and bankruptcy still mean that things get bad, you'll have to consider options of closing things down. One option is administration. A company can be placed in administration when the directors for a company form the opinion that the company is insolvent or likely to be insolvent. In this situation, an administrator, who is an external party to the company, will be appointed to manage the company in the interim. Another option is winding up. A company may be ended, that is, wound up, by selling company assets and distributing the proceeds amongst creditors and shareholders. This may be advised if the company becomes insolvent. A company can be wound up by the court, or it can be voluntarily wound up by resolution of the members. Once a company has started going into administration or winding up processes, you cannot take legal action against it in the court, unless of course the court allows it. So if you are experiencing severe financial difficulty, there will need to be some tough calls made during this time, which place the business into a minimal holding position until the pandemic is over. Be vigilant in getting on top of your cash flow projections. Consider what options you have for dealing with wages and staff. Communicate transparently with contractors, suppliers, staff, and key stakeholders. Ensure your company does not enter into any new debts. If necessary, ask for help from the banks to secure loans for short or long-term assistance. Look at your employment agreements, enterprise agreements and modern awards to see what your rights are in respect to staff. Most importantly, look after yourself. During this stressful time, it's important to look after your mental and physical health. Try to maintain physical activity as best you can, even while self-isolating. Meditate and talk to friends and families and Indigenous business networks. Check out forums and take a break from work. And remember, we're all in this together. And remember, our ancestors have survived for countless of generations, and we will get through this. We hope this information will be useful to you and that your business survives during these challenging times. And if you want to watch more of these videos in this series and get more information and advice during the pandemic, go to iba.gov.au.